Yes, trace and access?
Well, just before I get to trace and access, as you probably predicted, I just want to revisit something in answer to Lord Justice Popplewell, and to answer, I think, Lord Justice Nugee's point as well. If I could just go back to exclusion 9, and why I say this is a red flag. I stress the word but. And how that fed through. But of course, this is effectively an all risks policy. So it's any cause, not excluded. So in fact, there's no need in this type of policy to write anything additional in. So that's why the words "we will pay for damage to the property insured, not otherwise excluded, A and B," is not an addition, because there's no need for an addition. Things are covered except they're excluded.
Yes, I follow. Thank you.
If I can stay with this point as well. One of the matters I'm seeking to persuade your lordships about is that damage caused by pollution and contamination in the first line is not limited to proximate causes. And if one then goes to A, for example, the natural reading of A is pollution and contamination which itself results from a specified event. The natural reading is that the specified event there is a proximate cause, which rather points then to pollution and contamination which results from the proximate cause specified event being something other than a proximate cause.
Is that because the words results from
yes,
has been interpreted as meaning proximate cause?
yes. And similarly with B, again, proximate cause specified event, that says results from pollution and contamination. But there, of course, that would be saying that pollution and contamination was the proximate cause in B. Results from.
So the effect of your submission then is that the pollution or contamination need not be the proximate cause, so long as it is somewhere in the chain of causation, and likewise the specified event need not be the proximate cause, so long as it is in there somewhere.
Well, yes, I think that's a fair summary.
I'm not sure that's what you were saying the effect of A was.
Well, the A is
specified event couldn't be more remote,
but not in that,
cause.
Not in that context, not in A.
But I thought you were from B. That's where
from B, yes, my lord, from B, but not.
It can be more immediate than proximate cause, because B, you say, is where the pollution or contamination is the proximate cause.
Well,
but it can't be more remote than the proximate cause, because A, you say, only goes back to the specified event.
Specified event, which is
proximate cause.
Yes, and therefore makes it more immediate. Yes, makes pollution and contamination more immediate. Before I leave this,
but it's therefore not quite right for you to agree with my lord that specified event is sufficient if it appears anywhere in the chain of causation.
Well, that's probably right in the general sense. Sorry, in the specific sense, but in a broader sense. I was agreeing with Lord Justice Mayers, because I could see how it played out in both contexts.
Well, I was only asking how you were putting it, which was I wasn't suggesting that it was right. I thought my summary was what you said, but maybe it needed some refinement.
Can I ask a stupid question? When you're looking at A, if I've understood correctly, the answers you've given to my Lord or Justice Popplewell, indeed probably both my lords, are that the the words results from in A only refer to the case where the specified event is a proximate cause. Is that right?
Yes.
But what results from the specified event is not the damage, it's the pollution or contamination. So you can have a specified event which is the proximate cause of the pollution. The fact of the pollution then causes damage. Those are the words caused by pollution or contamination. Does it necessarily follow the specified event is the proximate cause of the damage, or could you have different proximate causes of different things in the chain?
Certainly, the chain is going to be specified event, pollution, contamination, damage.
Yes, I understand that. And I understand your case is that a specified event is the proximate cause of the pollution, because that's what the words results from mean. Does it follow the specified event as the proximate cause of the damage? Or could it be that it's the pollution or contamination which is then the proximate cause of the damage?
Well, what I'm saying, you're suggesting there's two proximate causes.
Well, no, I'm asking you. Does it follow from the fact the specified event is the proximate cause of the pollution that the specified event is also the proximate cause of the damage?
I think that does ordinarily follow.
It does ordinarily follow.
It does ordinarily follow. Yes.
Right, thank you.
But the point I was trying to make, very badly obviously, was that the pollution and contamination is a more immediate cause, less remote cause than the specified event.
Yes, well, I see that.
And that's why I say that the first line of this is not limited simply to proximate causes,
I see.
but to wider causes. Before
So can I just follow that through? If you have a leak which is caused by a sharp object, then you have a process of pollution or contamination in the leakage, and then you have a fire which causes the damage.
Yes.
Is that covered?
Well,
it's excluded under the introductory rubric in your
yes.
analysis. It's not covered by A
No, but
in
the
your
fire.
analysis, and B, I think you said, only covers a case where the pollution or contamination was the proximate cause. So it wouldn't come in under B.
Well, but the specified event there would be the fire, wouldn't it?
Yes.
B,
Yes.
which results from pollution and contamination,
Yes.
which in that circumstances wouldn't be a proximate cause.
No. But I thought you said that we have to interpret 9B consistently with 9A, where the words that follow results from are words imputing proximate cause, so that it's got to be a specified event which results from pollution or contamination as a proximate cause. I thought that was what your submission was on B, if I got that wrong.
My Lord, I think I may have not expressed it exactly. I would suggest in B, the proximate cause has actually got to be the specified event. That's my instinctive reading of that. Pollution and contamination could be the specified event. So it could be the proximate cause. Can I examine it in this way, in a very practical sense? What would happen if you had, during a policy year, just simply one policy year, as probably does happen, you have hundreds and hundreds of spillages on a forecourt? Now, those are going to be accidental spillages, perhaps by the motorists who are filling up their cars. what's going to be the proximate cause of that? It's going to be the negligence or the incompetence of the people filling up their cars. One wouldn't say, would you, that the acts of filling up their cars and overflowing and letting it run out, or leaving fuel in the pipe, or even spilling the oil as you're trying to put motor oil in the car, is that a proximate, the damage you're doing to the forecourt, is that proximately caused by pollution and contamination? Or is the proximate cause the negligence? Well, if it's the negligence of the customer who's on the forecourt, then that's not excluded if we're limited to proximate cause here. And if that's right, then you would one not get in the position that every year a garage owner could say, actually during the course of this year there's been lots of accidents by my customers and that has damaged my forecourt. Since this policy covers any cause not excluded, and silliness and inadvertence by customers is not excluded, can you please replace my forecourt?
Why not, if you can show damage?
Well, that is happening every day, is it not, on the forecourts of this country? So one of the consequences would be that you'd be able to say, well, actually, I've now got a slab and maybe some subsoils and grounds.
I don't think that is the consequence every day, is it? Well, I don't assume it to be right.
Well,
I think most garage forecourts are built to survive the occasional accidental spillage, aren't they, by motorists?
Well, the accidental spillages go into the concrete. You know, that's where they go.
Right, but whether that actually gives rise to any real damage, economic damage, it isn't obvious to me. That's all I'm saying.
Well, that's all I'm saying is it can happen over a period of a year, and one well knows that, for example, if one was buying a property or buying a former garage, that usually the ground's going to need remediating because of all the pollutants that have soaked through into the ground over time. I'm just trying to think of the practical consequences of this clause, because my submission, my overarching submission, is this clause is designed to exclude liabilities for oil and fuel and other leaks and things in a motor trader's policy. That's the very reason, in my submission, this is here. And that's why A and B are worded in the way that they are, because of the general exclusion.
Can I then just go back and see if I've got your submission on exactly what's meant by A and B? A covers cases where the pollution or contamination is more immediate than the proximate cause, and results from means that it only covers the case where the specified event is the proximate cause.
Yes.
Whereas in B, it's the specified event which must be the proximate cause, and results from means resulting from pollution or contamination as a more remote cause than the proximate cause.
It is a more remote cause, yes.
So we're giving a different meaning to the words results from in each of the
well, that's, yes, and in a sense that's unattractive. I can recognise that. But even if in B, pollution and contamination was a proximate cause, and a specified event a more immediate cause, that would still support my argument that the first line of exclusion 9 addresses a whole range of causes and is not simply limited to proximate cause. Well, that takes me back to where I was before the short adjournment, which was on the trace and access clause. And here, they're dealing with effectively the digging up costs and the filling in costs when they find they've got a problem. So it's the cost of locating the problem and then afterwards making good. What is not covered here is the costs of actually repairing the problem or addressing the problem as such. But why I rely upon this clause is because it shows that in this section, what was in the contemplation of the minds of the person drafting it is an escape of fuel oil from any tank apparatus or pipe or leakage. So they're considering it in the context of digging up and making good. But when it comes to the specified events, they omit it. They don't write cover back in for the escape of fuel oil from a tank apparatus or pipe.
Just pause for a moment. I understand your point, that you're going to make a point on the scope of specified events and whether you need the trace and access or not. The specific reference to escape from water might lead one to the conclusion that they will have had in mind the alternative of an escape of fuel oil. But before you get to what effect the specified events limitation has, what else, if anything, do you get out of trace and access other than the suggestion that fuel oil leakage is something that the parties would have had in mind in this policy?
That's the core point I get out of it.
All right. Which one might have thought would be blindingly obvious, irrespective of any of the clauses. And I have to say, if one's having an all-risk policy for a business which includes a filling station, the risk of oil leakage would seem to me to be a risk which both parties would regard as one which had to be addressed in terms of cover. It's a pretty obvious risk, isn't it?
Well, it may be that that's the very reason you have the exclusion 9, to cover that from risk in this case.
That doesn't tell you how they've decided to get to cover the risk, but if all the point is that you're making, the parties must have had in mind a risk of fuel leakage. I'm not sure that you need to point to the trace and access clause for that purpose. That was the only point I was making.
That takes me then to the specified events clause, where this is not mentioned as a specified event.
Yes.
And really, picking up your Lordship's point, if they had wanted to provide cover for leakage of fuel oil from tank apparatus or pipe, had that been the intention, then it would have been provided for within a specified event.
Well, you'll just need to spell that out. That is so if you are right about your construction of exclusion 9, namely that in effect it limits cover and provides cover to losses caused by specified events. But that's the question we're trying to answer. Why does the fact that it's absent from the specified events dictate that construction of exclusion 9? Can you just spell that out for me?
Well, if exclusion 9A covers specified events, specified events which lead on to pollution contamination, which lead on to damage. If that had been, and if the intention had been, then for the purposes of A, there was going to be cover for a fuel leak from apparatus that leads to pollution, that leads to damage. Surely they would have written it in to the definition of specified events. They would have written in fuel leak into specified events to show that it was to be covered. The fact they didn't,
if it wasn't excluded in the first place and didn't need to be written back in A, how does its absence from specified events help you? The difficulty I'm having, and it's a genuine difficulty, and it may just be I can't quite get my mind around it, is whether you're starting from the proposition that exclusion 9 it excludes this, notwithstanding that it's not a proximate cause, and therefore it has to be written. And therefore, if leakage is going to be covered at all, because all leakage is going to involve it, pollution or contamination as a process, if leakage is going to be covered at all, it has to be covered as a specified event. And the fact that it's rather carefully not one of those means that the parties didn't intend to write it back in as a specified event. So far so good, if the premise is correct, that pollution and contamination is excluded whether or not it's a proximate cause. But how does it help us with that question? Because if the exclusion is only of pollution and contamination as a proximate cause, then in cases of fuel leakage, in the vast majority of them, they won't be excluded, and we won't need the right back. And the right back, or the extension, whichever expression you use, is actually covering a wide range of causes for a fairly limited set of circumstances.
Your Lordship's right in the sense that my submissions have been based on the premise that the first sentence excludes all causes, whether proximate or not. You're absolutely right about that. What your Lordship's now putting to me is, please read the first part as limited proximate cause. And then how does the specified event help? Well, I suppose one goes back and has to simply make the point that there would be no need for the additional words if the first line was limited to proximate cause, because it's all covered by any cause not excluded.
I follow that, and that's your submission. Just looking at the exclusion. What I'm struggling with slightly is what there is that points in either direction from the fact that specified events doesn't, and you might probably say quite carefully doesn't, include as a specified event escape of oil as such.
Well, I suppose you can go no further than saying, or I can go no further on your Lordship's question to me, on the assumption that the first line is limited to proximate cause, to say that you don't need the rest of it if that was right. And therefore, why have we got all these limited definitions of specified event? I suppose it goes back to the same point, that if damage caused by pollution is limited to proximate cause, then if it's not proximately caused, it's going to be covered.
Well, we know we've got a whole series of specified events, and we know they have a function, and we know that function is that they provide cover in the circumstances in which A and B apply, whatever it may be, which ex hypothesi are circumstances where cover would not otherwise apply. That's what a right back is. So we know there is a right back, and we know it's by reference to a whole series of events. But I'm still struggling, I'm afraid, to see what the significance is of the fact that that right back is by reference to a definition of events that doesn't include escape of fuel oil as such, although it'll cover escape of fuel oil as a consequence or a cause of any of these other events.
Well, I think I'm just going to repeat myself here. I'm not sure I'm advancing things. I just say that if it is a right back, as I argue it is, then the fact that you're not writing back in cover for a fuel leak rather makes the point that cover for a fuel leak is excluded. And the place to have written it back in would have been within the definition of specified events. My Lord, if I may move on, looking at the time. I'm just going to deal very briefly, if I might, with the two cases of, in my submission, particular relevance. The first one being Legg, and the second one being Beckett. My learned friend has very kindly taken your lordship through some of the elements of Legg, but in my submission, it's not such an irrelevant case as my learned friend invites the court to find. Essentially, the key facts for Legg are: it was suggested on the evidence that there was a leak in 1997 from an above-ground tank. 1997. That was one possible problem and cause. The second factual matter in Legg that's important is that it was then suggested that, in fact, there was a completely separate leak, a long leak from an underground tank that had been going on for a long period of time. Broadly speaking, the claimants in this case were alive to the policy and said, we want to rely upon the above ground leak because that suits the policy conditions. The solicitors for the insurers then took a limitation point. And to get around the limitation point, they really changed their case. And they said, actually, no longer do we want to rely upon the limitation point. No longer do we want to rely upon the above ground leak. We now want to rely upon the below ground leak, because that had been going on for a longer period of time, and some of the losses and damage may be within the limitation period. That's essentially what happened in this case. The relevant insuring clauses, my lords, is at page 393 of the judgment, which is at tab 6 of the authorities bundle. And it's in the right-hand column, the second column, paragraph 17. There is cover subject to the exclusion. And we see the exclusion about 1.5 inches down in paragraph 17. Namely, liability arising from pollution and contamination of buildings or other structures, or of water, land, and the atmosphere. And what was being said here is that the escape of fuel from either tanks was arising from pollution and contamination. It was the right back at paragraph 18 that the parties were interested in, because it said, other than caused by a sudden identifiable, unintended and unexpected incident. So the claimants were relying upon the leak from the above ground tank because that would have satisfied the right back. That would have satisfied the exception in 18. When they changed their case because of limitation issues, they could no longer rely upon the right back in 18 and was scuppered, therefore, by the exclusion. And this is not wholly irrelevant, because as a result of being scuppered by the exclusion, insurers were able to say, well, there's no cover. And because there's no cover, they were able to say, we're not liable for costs, or at least that was their argument. And one can see that from paragraphs 65 and 66 of the judgment. So insurers submit that their liability to indemnify Sturt against either compensation or costs and expenses arises only if an insured event has occurred.
Sorry, where is that?
65, my lord, page 398. And so, whether or not there was cover had actually been material to the costs argument. It proceeded, though, on the basis that there wasn't cover. And the point I rely upon this judgment for is paragraph 28, where Lord Justice David Richards, as he then was, it's page 394 of the report, says that damage resulting from such leakage, and here he's talking about the leakage from the underground tank, basically ongoing leakage over a period of time, would fall outside the public liability cover for pollution damage in section E, which is that provision in paragraph 17 of the judgment, namely liability arising from pollution, contamination of buildings. Now, I take the point that's been made earlier that arising from is not the same necessarily as caused by. And my Lord Justice Popplewell is right that there is conflicting authority both ways. There's a passage in the Crowden case that actually identifies that, my Lord, just for convenience. It's paragraph 70. Where Peter MacDonald Eggers, who's sitting as the deputy judge, notes at paragraph 70, about halfway down, the words arising out of, which he puts in brackets, which has been variously construed as requiring a proximate cause or some lesser causative connection. I can't, without going back to the books, etc., assist any further on that at this stage. But what I rely upon it for is, though, to show that in this case, both counsel and the Court of Appeal were dealing with circumstances where there had been, were presumed to have been, leakage from an underground tank. And they thought, in that case, it was liability. It amounted to liability arising from pollution and contamination. Now, the cause of that leak in the underground tank, whether it had been some sharp or whatever, is not known. But it was sufficient, there was a sufficient causal connection for the purposes of that exclusion. The only other case I wish to trouble your lordships with is the case of Beckett, which again my learned friend has kindly taken your lordships through. But I wonder if I can just highlight a few facts. At the back of it's tab 5 of the authorities bundle, and right at the back of the report are some maps or diagrams. The first diagram, which is perhaps the most detailed, has buildings identified on it, including 2 with the identification marks F1 and F2. And those are the buildings that this case is concerned with. If one goes to the second diagram, one can see in the middle of the page the building that is referred to as F1 and F2. And one can see a dark line running from the bottom to the top of the page. If it's any assistance, one can also see 2 dark spots. Those 2 darker spots in the second, one in the second grid from the bottom, and the other one also in the second grid from the bottom, but to the right. Those 2 dark spots are in fact mine shafts. And the dark line I'm referring to is the line slightly to the right of the most right mine shaft. That dark line is a watercourse, is a natural watercourse. So what this is showing is a natural watercourse running up the page to, in fact, what is the canal, and 2 mine shafts. And then if I may trouble you and go to the next plan. On here you can see a large rectangle towards the bottom of the map, and that again is buildings, largely buildings F1 and F2. The important point here is that one can see some lines drawn on this, particularly option 1. And option 1 essentially runs across the page, going slightly down, and turns into some dotted lines and an arrow leading into the canal. In very broad terms, that is the watercourse, and what one sees are a couple of small squares with numbers by them in the vicinity of that line, which are natural springs. So what I tried to do is just set out the factual context for this case. And what you had on the facts of this case was water coming up through the natural springs and attacking the building. But you also had water coming from the mine shafts and attacking the building. The water coming from the natural springs was said to be leaching things out of the concrete of the building and adding more sulphur. And so you're getting this mixture of leaking and a sulphur attack from the natural spring water. From the mine water is referred to, the water coming from the mine shafts is referred to as the ochreous, ferruginous water in the judgment. My learned friend is right that the judge decided this case on the grounds that there was not accidental damage. Basically, he found that the degradation of the concrete into a mush was bound to happen, given this water situation. And my learned friend is right that at page 443 of the report, he sets out the summary of what was happening. And really, paragraph 169 is the most relevant for our present purposes. The flowing water, this is the naturally flowing water from the springs, caused both leaching and sulphate attack, and eventually reduced the concrete blocks of the building to mush. But he did go on and consider the effect of the mine. If I could go to just page 448 of the report, and in the right-hand column at paragraph 196, there the judge sets out the issue with the mine water. Makes the point that elements in the water gave rise to the contamination of the water because you could see it on the building and damage to the blockwork. And in paragraph 197, he says, I'm satisfied, but whilst this was a secondary cause of the damage and whilst failure to locate and deal with the mine shafts at the time of construction was a further failure on the part of those responsible for planning and design works, I'm not persuaded contamination from the mine water was a serious or significant problem. He says, in other words, even if mine shafts had been dealt with, I consider that the leaching and sulphate attack would still have occurred and would still have meant that this cracking would have happened. Essentially, what he finds on the facts is that the mine water doesn't really satisfy the but-for test. But when one then comes to the contamination exclusion, which is at page 456, in the report, he says right at the bottom of that page in paragraph 264, accordingly I find on the balance of probabilities that there was a source of contamination on this site because the mine shafts which were identified with British coal were located. And then 265. However, I'm also clear that the damage done by the ochreous water and ferruginous material was limited. There's nothing to say that it did anything more than exacerbate some of the damage that would always have been caused. And he deals with the but-for test. But then in paragraph 266, he says, accordingly, had it been relevant and had the contamination caused by the ochreous water and ferruginous material been the only excluded cause relied on by the defendant, I would not have found that it caused the relevant damage. The contamination exclusion was not therefore applicable. So what he's actually finding here is that the contamination clause actually applies, if I can put it like this, in substance on its wording. He finds that the contamination exclusion would have been triggered by the mine water and the way it attacked the concrete. But, he said, as a matter of but-for causation, it doesn't satisfy the but-for causation test, and therefore there's recovery under the policy. So it isn't actually effective on the but-for causation point.
If it had only been the ochreous water and there hadn't been the springs, what would have been the proximate cause of the damage? It would have been the contamination.
It would have been the contamination by the ochreous water, yes. That would have been it. And that's the point I rely upon.
But that doesn't tell you whether the contamination clause requires contamination to be the proximate cause or any cause.
No, but I should have said, and this is an error on my fault, in this case, the contamination clause was virtually identical to the contamination clause we're dealing with in our case.
I understand that. But my point is, do you get any assistance from what he says? He says it would have fallen within the contamination clause if it had been the cause, but there's no competing cause. It is just the contamination.
Well, no, there is a competing cause because it would have been the mines. The cause is that you haven't actually properly addressed the mines when you closed them off or you stopped working them. And so you were permitting, essentially, this ochreous water and this ferruginous material to be escaping from the mines. That would be the equivalent, effectively, of, in this case, what is assumed to have happened, a stone or sharp puncturing a line. Of course, in this case, it's not known how long that hole had been present and for how long the oil had been leaking. There's obviously questions of fact between us.
So your submission is that the pollution and contamination from the mines in this case would not have been the proximate cause?
Well, I think what I'm saying in this case is that the ochreous and ferruginous material which attacked the concrete and caused damage was the cause of that damage, because that's what it said.
I quite understand. If you're just taking us to this defensively, as it were, and saying all this is a case of its particular facts in which a particular source of water was determined not to be causative on a but-for basis, so you don't get anything out of it at all. I entirely understand that. I like Lord Justice Nugee, was wondering whether you was trying to say you get some assistance out of this because the pollution or contamination was treated as something which would have been excluded if causative, and on the facts it would have been a non-proximate cause. But I don't think you are saying.
Well, I was saying that because I was saying
So
on,
you
the
are,
facts, on the facts, not
you are or aren't saying that?
not in terms of proximate cause. But what
No.
I am saying on this is that the exclusion in this case, in the Beckett case, would have been but for causation point. And
That's because the pollution or contamination was the proximate cause, so that it doesn't really help us as to whether, if you translate it to our case,
I suppose what I'm saying is
the leak is or isn't the proximate cause, or more importantly, whether the clause only covers proximate causes.
what I was saying is that wherever it's originally came from, the original cause of the ochreous and the ferruginous material wasn't really the point that mattered. It was sufficient that it then infected the concrete, and that infection of the concrete was seen as a sufficient cause for the exclusion, which supports my case.
Or would have been had that.
Yes. So I rely upon it to show that it's a sufficient cause for the exclusion to have been in this case. Very much in the same way that the fuel permeating into the slab and the buildings, etc., is a sufficient cause for the exclusion on the facts of our case.
But it's only analogous if the water from the mines in this case is not the proximate cause, isn't it?
Well,
Otherwise, it tells us nothing about whether this clause bites on proximate causes or more
I don't
immediate causes.
I don't think it had to be the proximate cause. It was sufficient that it was a cause for the exclusion to bite. Nobody seems to have considered whether it was a proximate cause in this case.
No, and it may have been. We can't tell from the report.
No, but that's my point is, because they don't address proximate cause as such, it's sufficient for the exclusion if it was a cause. Because the exclusion in this case was virtually in identical terms. You can see the exclusion, Lord, at page 421 of the judgment.
Not only does it not address whether it was the proximate cause, it doesn't address even the question whether that matters, does it?
No, no, it doesn't.
It doesn't really tell us very much.
Well, Lord, I think the only thing I can add is that if one looks at the clause here, which is on page 421, and it's in paragraph 8 of the judgment, but it's paragraph 5 is the relevant clause. There, the clause is damage caused by pollution or contamination. There's another but in this. And it goes on, this shall not exclude. So, but this shall not exclude damage. Rather, in my submission, helps me to say that the but shows that it would be excluded, and therefore this is a right back. And then the only other difference in terms of the clause is they use the word defined peril, whereas in our case we're using specified event. But if you see defined peril is at the top of the page, it's, as far as I can tell, in identical, or if not, very, very similar language to specified event. Now, my Lord, I said I had two other points. But in the way that matters have developed today, I'm not really proposing to say anything more about them, unless Your Lordship wants to hear me on the point about whether or not this is dealing with damage which is consisting of, rather than caused by, or whether you want to hear me on whether you should apply the contra profferentum test.
No, I think you focused really on what seems to be the real issue between you and Mr. Davidson. So,
Okay, unless I can assist further.
Okay, can I just raise two further matters? I think, but tell me if I'm wrong, you accept that on the assumed facts, the proximate cause of the damage with which we're concerned was not contamination or pollution, but was the contact between the sharp object and the pipe. You haven't addressed any of the cases that Mr. Davidson took us to, and I had understood your argument to take that as the starting point, but say that's not what the clause is about. Am I right?
I think that's a fair point.
Thank you. The second matter I wanted to ask you about is this. If you're right, what's happened in this case involves there being no cover for the relevant material damage. If the same had occurred, assumed facts had occurred, but the spillage had caught fire, then I think you say, do you, that the damage would be covered?
Well, I think I start from the thing, if it had caught fire, then one would ordinarily expect it to be covered anyway, without even considering this pollution for the moment, because it's any cause not excluded. And I don't think there's a standalone fire exclusion.
No, but fire wouldn't be the proximate cause in those circumstances, would it? So you'd have to, if you're just starting, if all you had was an all risks policy, you would have to identify proximate cause, and you'd have to look at your exclusions to see what effect they have. And you would go to exclusion 9 because pollution and contamination have been part of the causative process, and you would say excluded under the first part of clause 9.
Yes.
But I think, but I'm not sure, you would say, but that comes, the damage, if it's caught fire, would come back in under the specified event
Yes.
cover.
Yes.
Because it would come under B, it was caused by a specified event which itself resulted from pollution or contamination.
Yes, that's right. That's right. That's what I do say. And I think that's one of the examples I give in the footnote in my written submissions.
Isn't that an rather odd result? That cover for what is essentially the same casualty and the same spillage depends upon whether it happens to catch fire or not.
My Lord, no, because here one would, in those circumstances, be really saying, the average policyholder would really be saying that the cause here was the fire. It's the fire that's really been the cause. It's the fire that's done the damage. It's the heat and the burning that has done the damage. It's not the chemicals that have done the damage. See, the problem here that we have in our case is it's the chemicals, it's the fuel that's done the damage. But in the example you give, the real damage, my submission cause, would have been the fire itself. That's a very different type of damage. It's burning it, it's destroying it. It's reducing it to ash. We're just dealing with where it's infecting it. And I say, no, it isn't an odd result, because the whole purpose of this policy, in my submission and this exclusion, is to avoid cover for fuel leaks of different sizes, different types, which can pollute the property in this case, whether it's from customers, whether it's from tanker drivers, whether it's from other causes as well.
Causes other than specified events.
Other than
So it's to avoid cover for fuel leaks, but only for some of the consequences of those leaks. Because if the consequence is fire or explosion,
yes,
if it's, as it were, pollution simpliciter, say it's out.
it's out. Because those, if you look at the other specified events, they're of a different type in their impact upon the property. Fire has a major different impact on the material damage to the physical property. Lightning is going to burn it or explode it. Explosions themselves, etc., etc. The result of these specified events is very different.
Well, is that right? What about malicious acts?
Yes.
Sorry, say sorry.
I was going to say malicious persons.
What about malicious persons? The anti-fossil fuel protesters decide that it would be helpful to come onto the forecourt and smash up the pumps, as a result of which there's a leakage.
Well, in that
That's
case,
covered, isn't it?
in that case, that is covered.
Same kind of damage, but it's covered.
That is the same type of damage. I accept that. But most of the others, if one looks at them, would be different types. Fire, for example, is a good example.
Earthquake causes the rupture of the pipe.
But in the ones that your lordship is now identifying, those are specific causes. So why trouble oneself with these specific causes rather than just having a blanket? Everything's in, no matter how.
I was just cavilling with your suggestion that fire's different because it's a different type of damage, whereas actually what we're talking about here are different causes rather than different types of damage.
Well, I'm sorry, I was responding to the fire example, but the wider points you make, my lord, are in relation to earthquake, storm, flood, etc. If they had in some way caused pollution, they're identifying specific events to cause pollution. They could, for the policy purposes, have just identified some form of pollution irrespective of how it happens. The very fact that they've limited how it might happen shows that the cover here for any contamination is only going to arise from certain events, not generally. And it's that general cover for contamination by fuel that the policy seeks to exclude, because it's going to happen, my suspicion, fairly frequently. People making mistakes, dripping onto the forecourt continually, very often. I'm sure it happens, several times a day at most garages. And yet that is causing damage, for which there would have to be a remediation cost. And if your lordship's right, they could be asking for that to be remediated, because this has physically damaged it, unless they can somehow remove the petrol contaminants from the concrete. So if it was going to be, as your lordship's saying, an odd result, in that there should be cover for this type of damage. I think it has to be a bit more nuanced than that. They are, by specified events, they are only covering damage from certain specific things, resulting in pollution and contamination, earthquake, etc., being those things that cause pollution and contamination on specified events. They're not providing cover generally for pollution and contamination. Those are my submissions.
Thank you.
Thank you very much, Mr. Davidson.
My Lord, one tends, in any case of this kind, or at least I do, and I think my learned friend has, whether he generally does or not, to focus one's arguments on interpretation on the particular circumstances which have arisen. And my learned friend came to that just at the end of his submissions, when he was suggesting that the particular purpose behind exclusion 9 was in fact to exclude the occasions of fuel leaks. And that submission, I would suggest, is a little bit driven by the circumstances of the case, because the exclusion is much more widely directed than that. It may be, and the judge has held, that it does have that effect. As you know, our submission is that it does not. But this is a fairly wide-ranging exclusion, which perhaps reflects the forms of the fact that pollution and contamination are things which can happen through a wide variety of circumstances. It may be simplistic to say that obvious examples are those involving gases of one kind and another, or liquids, whether there's liquefied gas or not, or indeed particles, so that one has, in common speech, examples such as acid rain, toxic water, exhaust fumes, fuel vapour. My Lord Justice Popplewell's particle example of soot. One could take also ashes, in addition to the red sand which I mentioned. The exclusion seems to be directed to anything which could be described as contamination or pollution. What is difficult is to try to work out whether the intention of this policy is directed to proximate causes or not. And the various excursions into the wordings often seem dead ends. Thus, for the reason given by my Lord Justice Popplewell, the trace and access extension doesn't really assist, because one starts with the fact it's fairly obvious that there could be a leak of fuel one kind and another in a retail station which is providing fuel. One then starts to look around the exclusion itself and the specified events policy, and it certainly doesn't provide for natural or easy reading for anyone to look at those texts. It perhaps almost comes down to this, that in the list of specified events, one has a large number of possible events, including one which clearly isn't an event at all, which is simply aircraft. But in what is, I think, the fifth line, you get the words escape of water. And it is almost being said that the interpretation of the exclusion is driven by the presence of the two words of water, so that if the specified events simply read escape from any tank, apparatus or pipe or impact by any road vehicle or animal, it would have a different effect. And therefore, it is said, it is from the presence of the words of water that one should be driven towards the conclusion that the correct interpretation of the exclusion is that it's a broad one, and the opening line is not directed to proximate causes. That, I would submit to your lordships, is a fairly strained way of arriving at a conclusion as to what words mean, and take one into the territory where one should be very cautious about whether that is actually the result which this policy intends. It is also the case with the specified events that it is not necessarily clear at all when the specified events will or will not be proximate causes. It may be, in a particular case of difficulty, that it is reasonably easy to see that the proximate cause can be the malicious act of a person protesting against the use of fossil fuels. One has already the example of the fire taking place after the pollution or contamination, where it is debatable whether it is the pollution or contamination which is the proximate cause or the fire. So it is debatable whether one gets to the conclusion that there is liability on the basis of there being a fire, or on the basis that the proximate cause was pollution and contamination, and one is brought back into cover by the exceptions to the exclusion. It may well be, I would submit, that in the situation which is under consideration, the court would actually say, well, no, the proximate cause of the damage which has occurred is actually the fire, not the pre-existing pollution or contamination. And one doesn't have to go through the analysis of going through exclusion 9 and then reading back from the exceptions to get through exception B to the specified event, fire, in order to arrive at the conclusion that there is cover. The conclusion which my own friend argues for really appears to be that there is no cover where there is pollution or contamination unless one can get to it through either A or B and identify that there is a specified event. It's a rather roundabout way of saying that there is cover for damage which is caused by a specified event. My other friend referred in the later stages of his submissions to the Legg and Leeds-Bradford cases. And I maintain my submissions to your lordships on those, that firstly, Legg is not of assistance. The relevant passage in paragraph 28 of Lord Justice David Richard's judgment is dealing with the question whether the assumed liability of the insured arose from pollution or contamination. It was not dealing whether damage was caused by pollution or contamination. And it was clear that liability, if it existed, from the garage to the claimants, arose from pollution or contamination, which was the basis of the claims which they were making for the tort which they alleged had been done to them. And that does not assist on the question whether one interprets an exclusion of the kind with which the court is concerned as directed to proximate cause or not. I don't think it's necessary, unless your lordships want me to take you back to the pages. You have the point firmly in mind.
The claim by the claimants was presumably a nuisance, was it?
Lord, yes, and I think that Rylands and Fletcher was featuring as well, but that was the basis of the claim. on the Leeds-Beckett case, one does not know what the outcome would have been if the facts had been different. What is clear is that the judge's findings of fact meant that water which was polluted was not the or a proximate cause of the damage. If the situation had been the different one, that the only identified cause of the damage was the sequence: failure to seal mine shafts, presence of contaminated water from those mine shafts, leading to failure of the concrete blocks, then the question would have arisen. Is it right to say the proximate cause of the damage was the contaminated water, or the proximate cause was somebody's failure, perhaps many years before, to deal with mine shafts in a different way? The ordinary lay person would be likely to say, in such a situation, the cause of the damage was the contaminated water. I accept that an insurer seeking to rely on such an exclusion might argue that the proximate cause was earlier in the history and in relation to work done or not done to the mine shaft. It's an open question which way a judge would conclude that point. And it doesn't really assist your lordships to approach the present case by asking yourselves what would the outcome of Leeds-Beckett have been in different circumstances. They didn't arise, and Mr. Justice Coulson didn't have to deal with them. One just can't speculate usefully as to the answer. So, I'm afraid, as counsel sometimes won't do, I come back to my starting point. What was the proximate cause? There is no real dispute about that. On the assumed facts, the proximate cause was an event which is of the type for which cover would be provided, subject to exclusions. And caused by, in the insurance world, rings the bell. Your lordships, I hope, have the 4 pages now from the Arch case, which
yes,
discuss.
They arrived. Thank you very much.
What my learned friend is saying is there is enough here to push this exclusion away from being directed to proximate cause, to which I say that is not a natural way of reading an exclusion of this kind, where the logical approach is to be thinking, preliminary question is what actually is the cause of the damage in this case, because the first thing I have to decide within the terms of cover is this caused by a non-excluded cause, or is it caused by something which is not excluded? And one just says, well, what's the cause? Well, if you answer the question the cause of this is penetration of a pipe by a sharp object, you have answered the question, and therefore the exclusion is not engaged, even though a result of what one has identified as the cause is that property becomes polluted or contaminated. That being so, one doesn't get in to what I may describe, I hope not improperly, as the recesses of the judicial toolbox, right at the back of which one finds the contra proferatum material. That's only for the cases where you genuinely think there is an ambiguity, rather than, as it was succinctly put in one of the American cases, where counsel happen to disagree. It's a question whether there is a reasonably clear exclusion to the reasonable reader of the policy. And the reasons I've given to your lordships, I maintain my submission that this is a case where there is a clear cause, which makes one think, right, it's not an exclusion 9 case, and therefore there is cover. I've done my best to make my submissions clear, and unless your lordships have any further questions, I won't repeat myself.
I do, please. Can I just understand how you say exclusion 9 works? Damage caused by pollution or contamination in the first line, that excludes only damage proximately caused by pollution or contamination. Then when we get to the we will pay for, it's, if not otherwise excluded, it's damage caused by, that mean proximately caused by, before we get to A and B?
It doesn't necessarily have to mean the same thing. Because if...
What is your submission?
Well,
does it mean caused, approximately caused by, or does it mean somewhere in the chain of causation?
My submission is this, that in the first line, damage caused by pollution or contamination means proximate cause. In other words, damage which it is decided is the subject of the proximate cause must be pollution or contamination.
So far, so good.
So far, so good. In the third line, the words may and probably usually will direct the reader's mind to proximate cause. But the reader's mind may by this time start to wobble, but it is much more likely, on the basis that a draftsman, draftwoman, drafter is trying to be consistent, that it actually has to mean proximately caused.
So what is your submission on it? Does it mean proximately caused or not?
Yeah, I would go in submission for proximately caused.
Right. So then A provides for cover, which is proximately caused by pollution or contamination, but itself results from a specified event. So the specified event is, ex hypothese, a more remote cause. So where it results from there, it isn't proximate cause. It's pollution or contamination as a proximate cause, which is what it was initially taken out by the beginning, but is put back in if itself it results from a more remote specified event. Is that how that works?
The specified event appears not to be the or a proximate cause.
Yes.
Because there's a differentiation being made between caused by in the third line and results from in the immediately following line.
Yes, so your submission is results from is not a proximate cause test in A.
Yes.
We get to B, and again, do you say consistently that results from is not a proximate cause
Yes.
test? But the words any specified event are covered by caused by in the third line. So we are dealing here with, on your construction, damage which is proximately caused by a specified event, but results from pollution or contamination as a more remote cause.
Yes.
Right so far?
Yes, my lord.
If that be so, how do you square B with your initial, your submission on the introductory words, that if the pollution or contamination isn't the proximate cause, it hasn't been excluded in the first place. So there's no room for the operation of B.
We have a very odd sequence visualized by the drafter if one reads the first words of the exclusion going straight on to B, because then it reads like this: damage caused by pollution or contamination. We will pay for damage to the property insured not otherwise excluded, caused by any specified event which itself results from pollution or contamination. Because when one reads that free of the words in A, as the drafter intends one to do if B is engaged, you have damage caused by pollution or contamination caused by any specified event.
But if both caused bys in the introductory words should be read as meaning proximately caused by, then B gives you a bit of a nonsense, doesn't it? Because it's referring to damage proximately caused by pollution, but it then says, but will pay for damage not otherwise excluded, proximately caused by any specified event. So unless that is limited to the case where there are two proximate causes, one of which is pollution and one of which is a specified event, the clause doesn't work.
It is, I would submit to your lordships, a somewhat confused exclusion. Because here, if one is reading the opening 3 lines and going straight into B, you have the concept of something caused by any specified event which itself results from pollution or contamination, which appears to be suggesting that the damage has not been caused by that from which the specified event resulted, even though this exclusion is directed to damage caused by pollution or contamination. And I am entitled to, and do make the submission, that this is a confused and confusing clause because of that.
Is this right? On your submission, save in the unusual case of concurrent causes, B doesn't really achieve anything, so it's just for the avoidance of doubt type. Because if the damage is caused by a specified event, it doesn't come within the exclusion anyway. But that's what it logically.
Or you might say it's for the introduction of doubt rather than the avoidance.
Well, it is difficult. One that has to track back to the specified event and wonder exactly what the drafter had in mind as the circumstances in which these particular specified events will be somewhere in the history which has to be examined by the parties, and if they can't disagree, if they can't agree, by the court. That is why I mentioned the word aircraft, which rather strikes one as a word which is surprising to find as a specified event. What is it that the drafter has in mind as the sort of history which can actually produce these things? So it is obviously perfectly possible that some of them can, such as storm, earthquake, flood. Water is not the most polluting substance, one knows, but it can have contaminant effects as
Well, it is if it gets into an oil tank.
well, if it gets into an oil tank, exactly as we've seen in the cases. And it's not immediately clear with many of them how they're going to relate to the pollution or contamination exclusion. But the drafter had them in mind. Yes, with some of them one can perhaps be thinking, well, yes, it may result from something like this, I suppose. If you have civil commotion, you can start thinking what ends up if you get the air contaminated by tear gas, and that produces some deleterious effect. But it's all getting into quite abstruse territory, where it is easy enough for the logic of a clause to become very difficult to apply. And so I do submit that particularly when one's looking at the opening three words of the exclusion and then B, one arrives at a conclusion, this doesn't work very well, simply because the drafter's mind is varying about the concept of the significance of different causes.
I don't know if you've had a chance to check, but specified events is only used in exclusion 9.
I believe it's only used in exclusion 9, but may I undertake to carry out a search and report back via the learned friend. I think the learned friend agrees with me, but we'd better both check.
All right. Well, let us know if you find it elsewhere, but we'll proceed on the basis that it's not.
Yes.
For the moment, anyway. All right.
Well, I've done my best to answer Lordship's question. I don't know whether there are any other questions.
No? Well, thank you very much indeed.
I shall say no more.
Very good. All right. Well, we will reserve our judgments in this case. They'll be sent to you in draft in the usual way. You will know about the seriousness with which the embargo is taken these days, but I remind you, just in case, they'll be handed down in what is now the usual way remotely. We hope that you will be able to agree the terms of an order once you've seen the drafts. If not, we'll have short submissions in writing on any points that need to be resolved, and we will resolve them without a hearing. Thank you both very much for an interesting argument.